All right, we're back on the record and we'll call next People versus Michael Scott. It's file 24-6946FH for docket call and a status conference on a pending contempt for failing to appear. Mr. Scott's here with his lawyer, Mr. Nightingale, and the prosecuting attorney, Ms. Goodrich. Mr. Nightingale, do you know how we're proceeding?
Yes, Your Honor. We're going to ask for another docket call. Mr. Scott does have another pending case that's still down in district court right now regarding those allegations of failure to appear. And so not prepared to resolve that today. I'm hoping that we're going to get to a global resolution here on those files.
Okay.
We're scheduled for prelim in that matter on August 29th. So maybe that second day in September will give enough time for that case to catch up.
Okay, so continue this out to the September 30th then.
That sounds good.
And we'll do it at 10:20 for a docket call and a status conference on the pending contempt. Be September 30th at 10:20 a.m. Anything further from the people?
No, Your Honor, thank you.
From the defense?
There, thank you.
Okay, we'll see you then, Mr. Scott. Next, we have a sentencing in People v. Joseph Fawley, file 25-7018 and 7019. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
Good afternoon, or good day, Your Honor. Joe Bernoulli, appearing best on behalf of Mr. Fawley.
All right, and Mr. Fawley is not present, and Mr. Bernoulli, do you have any information about his whereabouts?
I do not, Your Honor. As of yesterday, I did speak with his mother, asking if she knew where he was. She did not. I have made attempts since July 3rd to be in contact with him. A second attempt again at the end of July 24th. I've sent formal notice to him as well at the last address that I had here in Sheboygan. I've not received any calls, and at this point, I don't see him in the courtroom, and I don't believe he's here.
Ms. Goodrich, any request?
Your Honor, I'd ask that a bench warrant be issued, given that it was sentencing scheduled for today, and he also was only on a furlough to rehab and was supposed to return after he left rehab.
All right, one of the charges that he's supposed to be here for sentencing for is on an attempted absconding as well. He's not here today. So we'll issue a bench warrant for contempt for his non-appearance with no bond. We'll address anything like that at arraignment once we do get into custody. Thank you, Mr. Bernoulli.
All right, thank you, Judge.
If do you want us to advise you if and when we get him in custody, so that if you want to zoom in for the arraignment, and then if you're not able to, we give him indigent defense counsel for arraignment purposes, but we'll at least try to reach out to see if you're available.
If you could, Johnny, there's got some things coming up in the next month with travel, and then work is kind of changing for the better on my end. So I just, my availability may be lessened.
Okay, great. All right, we're back on the record, and next is this Mr. Claypool?
Yes.
All right. People be Joshua Claypool. It's two file numbers, 25-7024 and 7025. FH up for a docket call in both. We've got Mr. Claypool here with his lawyer, Mr. Nightingale, and the prosecuting attorney, Ms. Goodrich. Mr. Nightingale, what's our status here in this case?
Judge, we got a global offer here that Mr. Claypool is still considering. If we could have one additional docket call, that would be our request at this time.
Okay, any objection, Ms. Goodrich?
No objection.
Well, it depends on how much time you think you need. I could have you come back in just a couple weeks on August 26th, or about 6 weeks out on September 30th.
If we could do September 30th, that'd be great.
Okay. Schedule this for September 30th at 10:40 a.m. Anything further from the people?
No, Your Honor, thank you.
From the defense?
So, yeah, thank you.
All right, we'll see you then, Mr. Claypool. Brings us to People versus Jared Martin, file 24-6842. Up for probation violation hearing on 2 alleged violations. Mr. Nightingale, did you receive a copy of, looks like the lab did send us a letter of interpretation of a couple of results, and I think that was sent out to all parties. Did you get a copy of that?
I believe that I did, Judge. Is that from Erica Walker? Or at least signed by
Yes.
Erica Walker?
Yes.
Yes, I have that, Judge, and I also have the actual lab results.
Okay. Do you know how Mr. Martin wishes to proceed?
Judge, he wants to resolve this with the court entertain some sort of no contest in regards to particularly allegation 3.
Did Mr. Nightingale, did Mr. Martin want to have a hearing today?
No, Your Honor, no. I think we're prepared to admit to the allegations.
Okay, Mr. Martin, would you please stand as best you can, raise your right hand for me? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Okay, you can be seated. All right, Mr. Martin, you understand you have the right to have a hearing where these allegations would need to be proven by a preponderance of the evidence, the right to the assistance of a lawyer to present evidence in your own defense and question any of the evidence presented against you. Do you understand those rights?
I do, Your Honor.
And you are on probation to this court for operating while intoxicated third offense as a habitual third, which would mean that the maximum penalty, if I revoked your probation, would be up to 10 years in state prison. Do you understand that?
Yeah.
Has anybody promised you anything in exchange for your admission today?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to make that decision?
Yes.
Knowing all this, how do you wish to plead to violating your probation, guilty or not guilty? How do you wish to plead to violating your probation, guilty or not guilty?
Guilty.
All right, so Mr. Martin, are you in fact on probation to this court for the offense I described for you? You're on probation to this court, is that right?
Yes.
And as part of that probation, you were to not use or possess any alcohol or controlled substances, is that right?
Yes.
And as part of your probation, were you required to submit valid urinalysis samples or urine samples for drug testing purposes?
Correct.
So on or about June 20, and you were also ordered on probation to successfully complete the recovery court program, is that correct?
Yes.
On or about June 25th, did you submit a urine sample for testing that ended up being a dilute sample?
I did.
And on or about June 25th, was a determination made that you had not successfully completed the recovery court program?
Correct.
Also, on June 24th, looks like that'd be the day before the dilute. Did you submit a urine sample for testing on the 24th?
I did.
And that was tested positive for alcohol?
I did.
And do you challenge or contest either of those test results?
I do not wish to contest, no.
Okay, Mr. Nightingale, you satisfied with the factual basis?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
Mr. Nightingale, are you aware of any promises, threats, or inducements at all?
None.
Ms. Goodrich?
No, Your Honor.
Mr. Martin, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you violated your probation. I'll set this for a probation violation sentencing. And this was an Otsego County transfer, but it had transferred into this court completely, meaning rather than refer it back to Otsego County Judge Mertz for sentencing, based on the agreement of the courts and the transfer, I'll be conducting the sentencing. I think you're not available on the 9th for training, so let's put this out for probation violation sentencing on September 30 at 10:50 a.m. And Mr. Martin, you'll have to cooperate with an updated pre-sentence interview or a pre-sentence interview so that they can prepare a probation violation report for me with recommendations about what to do next. Okay. Anything further from the people?
No, Your Honor.
From the defense?
No, Your Honor. Thank you.
Okay, we'll see you then, Mr. Martin. And then that brings us to Jonathan Zomberg. Mr. Nightingale, do you have anything else other than the arraignment on Somerville?
That would be my last year.
Okay, I guess, you can just, from where you are, I'll call that case. People v. Jocelyn Somerville filed 257042 FH for arraignment. Ms. Somerville, I was told to be zooming in. She did not zoom in. Ms. Goodrich, any request?
Oh, Your Honor, I'd asked for a show cause. I was in contact with the Emmett County Chief Assistant Prosecutor yesterday. She showed up for court there yesterday. She's in the process of applying to their recovery court.
Okay. We'll continue the arraignment to August 26th at 10 a.m. And we'll also use that date for a show cause for her failing to appear. So if you present me with that, I would sign that show cause.
Thank you.
Time to break this one down. The docket in People v. Michael Scott, Joseph Foley, Joshua Claypool, Jared Martin, and Jocelyn Somerville had more than a few moving parts, and Judge Aaron J. Gauthier handled each with the same even-keeled approach, firm when necessary, patient when warranted, and always intent on keeping the process fair and orderly. Michael Scott's case was first up, a status conference on a contempt issue for failing to appear. Defense counsel asked for yet another adjournment, citing a pending related matter in district court. The judge agreed to continue the case into late September, giving everyone more time for what the defense called a global resolution. No drama there. Confirmed the admissions were voluntary, and reminded him of the stakes, up to 10 years in prison if probation were revoked. Martin didn't contest anything, and sentencing was set for later. It wasn't dramatic, but it underscored the high stakes of recovery court. Second chances are real, but they aren't endless. Finally, Jocelyn Somerville didn't appear for her arraignment, despite being told to zoom in. The prosecutor noted she had appeared in another county the day before and was applying to their recovery court. Still, Judge Gauthier issued a show cause order along with a continued arraignment date. It was a measured response, recognizing her other efforts but holding her accountable for missing this court session overall. The atmosphere was a mix of routine scheduling, accountability checks, and a few reminders that showing up, both literally and figuratively, goes a long way. Judge Gauthier kept everything calm and fair, balancing flexibility with firmness depending on each defendant's behavior. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.